I watched the Lori Vallow motion hearing, and I have the highlights for you. I think this is going to be quite the trial, especially with how she acted today. So Lori had an objection to the jury questionnaire as she didn't agree with the phrasing of the allegations, and she wanted her denial of the allegations to be bolded and underlined. Judge overruled it because they already sent them out. Lori had a motion to exclude testimony of Daniel Coons, who was on the scene after Charles Vallow was killed. Now, the issue was he was listed as an expert witness. The prosecution says he is an expert when it comes to trajectory, and the defense has interviewed him already. It was timely noticed. Lori is rather upset because he was listed as an expert instead of a regular witness. She doesn't understand how trajectory has anything to do with conspiracy. Lori doesn't think his testimony is relevant and doesn't know how he is an expert. And the judge asked, well, since he was interviewed by the defense, what'd you think of that, basically? And Lori had not listened to his interview. The judge says he'll look at it, but my guess is the judge is not going to side with Lori. Lori has a motion that wants to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock as witnesses. Sorry if I have any of the names wrong or mispronounced. I typed all this out by hand. Their testimony is planned to be premeditation and motive. Lori's objection is that their information came from Dateline and each other. The judge asks, what information? Lori says whatever they're going to testify about. The state says Christina heard Lori say the victim was possessed months before the actual murder. Nancy Jo was the last to see the victim alive and told the victim that he should tell Lori he changed the life insurance policy. Kay Woodcock is the one who got the life insurance policy that the state says is the motive of the case. Lori is angry that everything, honestly. She was really mad. Lori is angry that in interviews the witnesses had with the media that they talked about talking to each other and that these people have watched television, that they've watched coverage of Lori. The judge explains that she can cross-examine them on that, but basically she wanted them thrown out because they've, spoken to each other, or like this is obviously at this point people have spoken and read about it, and there was a previous trial. It's nonsense from Lori, but she's very mad. And then Lori has a big smile on her face while the judge asked, is Mr. Eaton here? That would be Nate Eaton, who is a reporter Lori lists as a witness. Nate Eaton isn't there in the courtroom. I believe he was in the courthouse, though, but he had a representative in the courtroom. Now, Nate Eaton is the one who confronted Lori in the parking lot in Hawaii and does a lot of Lori Vallow coverage, so she's very aware of him. Lori complains she just got Nate Eaton's motion to be excluded last night when asked to explain why he is relevant to the case. Lori said he had an off-the-record conversation with the prosecutor, and that made him and her a witness. The judge asked, how is this relevant to this trial? Lori said he is there for impeachment and rebuttal because he has interviewed basically everyone on the state's witness list. Lori quotes Nate Eaton's motion where he said he believes Lori lists him to keep him from reporting in the courtroom. Lori said that wasn't her intention. She didn't even think of that, and she laughed at the idea of it. The judge gives Lori a chance and says technically he could come up on rebuttal, and asks Lori if she has copies of his interviews, and she says she took notes. Nate Eaton's representative said that this violates his First Amendment rights, and they would have to follow strict guidelines that are required to subpoena a witness that is a reporter, which Lori didn't follow. Judge says if they say something different than what they did in an interview, Lori can just play the video of the interview, right? You wouldn't need Mr. Eaton. Lori complains he interviewed basically all the witnesses. Judge thinks about it some more out loud and then just decides to strike Nate Eaton from the witness list. And he is, by the judge's statement, allowed in the courtroom. So Lori had a massive loss there. That's what she wanted. She wanted to hurt this man's career, and she failed. And I want to say how hard it is at certain points to say Lori instead of Sarah, because there's some Sarah Boone documents. But we'll get there in another video. State wants to stop the media in the court from sharing email addresses and phone numbers for witnesses and victims. Lori doesn't go against this. Basically, certain witnesses have not done public interviews, don't want to be contacted. That'd be a problem. The rules are already there for a 30-minute delay for the trial and that they can't show the jury. No sidebars can be showed, but they will add a new rule to not film phone numbers or emails. They need to figure it out, though, for like verbal, like if someone says, here's my phone number and reads it out, is there a way for like the media to beep it or mute it? The state's motion to preclude Lonnie Dorkin. Lori said he found a discrepancy from what he received and what was initially turned over by the state, but he needs more time. The judge said Lori refused a continuance to allow him more time previously. Any disclosure is late, but at this time he is likely to be precluded because the state wouldn't have time to have a rebuttal witness for trial. But they don't specifically say he's not allowed, but most likely not happening. Now, again, apologies if I butcher any of the names. Now it's time to talk about Lori's unserved witnesses, which are, to be honest, all of them, but the rest of them. If they are served, they need to be interviewed by the state. They also need to be relevant. Nate Eaton is out. Vixia Itiaho has no response from either side. Gabriel Bonilla, no response from either side, but state has contacted a representative from the LDS Church, which is representing him, saying he didn't get a subpoena. The judge stops here to ask, does the state not object to any of them? The state says minimal from Summer Shiflett. There's an issue because Lori had her name spelled wrong. Minimal for Janice Cox, her mother. Adam Cox is on the state's witness list. Zachary Cox, state doesn't know any relevance, but state spoke to him. Everyone the state has spoken to that they have gotten a hold of doesn't have a subpoena. Lori says her subpoenas are with OPDS and they're being issued. Lori angrily states that the state is claiming trial by ambush by the defense. Trial by ambush! That's what she exclaims it. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years? They have transcribed interviews. This witness list will fill in the blanks the state will no doubt leave out and will be called accordingly when needed. For foundation, Lori says, I feel like the state is trying to say, okay, you want your speedy trial? Well, guess what? You aren't going to let you defend yourself. You can't have any experts. Guess what? You also can't have any witnesses. You can't have anybody speak on your behalf. So good luck. Have a nice day. It felt so Sarah Boone, to be honest. It felt like Sarah Boone's spirit entered her. Judge explains that is why her prior and current attorneys asked for more time. You have to give notice to the state. Lori complains she is doing everything she can while being incarcerated at a maximum security jail. She does, that does not mean she doesn't get her constitutional rights. Lori is asked about the specifics that they could testify about. Lori says her father was a life insurance salesman who helped her with her policies and her husband's policies and tried to sell Lori's after Charles passed away, something like that. Her sister knows about Alex Cox. They're very relevant. Judge says saying they're relevant doesn't make them relevant. Sounds like Barry Cox might be relevant, but sounds like Lori doesn't know if it's relevant. State has the right to interview all your witnesses. Lori says they've all been interviewed, and the judge explains that doesn't mean police interviews. The prosecutor, in this case, has the right to interview them for this trial. Judge suggests they take it up as a case-by-case basis because he doesn't know if they'll even be served. The state says they tried to reach out and did a good faith effort, but she and the defense investigator can't reach them. Bringing them up later, if found, would be, according to the state, Trial by ambush. Judge put Lori on notice. If not served and submitted to interviews, they are precluded. Even if they aren't, if they're not relevant, they still might be precluded. So basically, Lori's witnesses are in big trouble for Lori. Her witness list is not in a good place. Lori says if she could call them herself, they would probably show up, but she's limited due to jail. And I am sorry about stopping to drink this so much. My throat is killing me today. I don't know if it's allergies or what. The people working for Lori have other clients, and they're doing the best they can. Lori's motion to dismiss due to violation of confidential information and Sixth Amendment. Lori has a lawyer working on her appeal in Idaho, and the state got jail messages. And the messages included her talking to her lawyer about setting up a secure line. The judge says this was on a public chat system isn't confidential, and the substance doesn't appear to raise an issue. Lori asks who is telling her this isn't confidential, and the judge says it looks like your own attorney was saying that, and reads some of the messages where they talk about getting a confidential line. He reads messages about trying to set up a confidential line. Lori says he got a letter saying his number is confidential, and to her that included messages. Judge said disclosures didn't happen after that. Lori says they do, which we'll get to it, but later it comes out that there were more messages coming from her attorney, but there's an issue with why that's happening. Dates don't seem to line up if it was shared after, according to the judge. Lori says, wouldn't it be protocol for the investigator to stop and ask for guidance on this? Which, from my understanding, no. The state requests messages, they got messages, and they legally have to turn those over to the defense, which is what they did. Lori says it's a problem. She read it, it was put into a motion, and they exposed his IP address, which is a federal offense. The judge has to explain. Her attorney, after getting his phone excluded, used different IPs to message her, knowing those aren't confidential, so he broke the confidentiality. The inadvertently intercepted messages aren't even being used. The judge explained the messages weren't sent by the phone number, it was using the IP that was not being kept confidential. Lori says there's no way for her to know that. Lori wants to know who is getting these and how. The state says her motion follows the law. Whether Lori didn't understand it, her attorney did. There isn't legal advice in these messages, it's just setting up for calls. Lori said there is privileged information. The state is now trying to testify for her attorney by saying that her attorney knew it was confidential. Now, couldn't Lori have brought her attorney for this or had them call in or something? Lori starts her same rant and the judge is just done. He says he won't rehash this. He isn't using the phone number. Lori asks how is he doing it, and the judge says he isn't explaining it again. He says they aren't using the messages, but your attorney is the one that used the system incorrectly. Lori asks how, and the judge says, I don't know how else to tell you. The judge says state isn't to spread them or use them, but dismissal is not appropriate. Now it is Lori's attempt for dismissal to prosecutorial misconduct. Lori says the state interfered in their investigation, which is a constitutional violation, prevented her from getting information from the police departments. Lori said they aren't getting things from the state or the police. State says they already gave her prior attorney what they requested. Judge says he was just told for the first time that the police department didn't honor the public records request, but there is a process to deal with that. Lori asks what that is, and the judge says he won't give her legal advice. Lori repeats the messages thing from the last motion in this new motion, and then complains that prosecutor gave legal advice to Nate Eaton. State says they just told Nate Eaton that he would have to be subpoenaed. Lori says she wants the prosecutor or Nate to be on the stand to say exactly what happened in that conversation. Lori says Nate Eaton's belief that Lori wants to keep him out of the courtroom came from the state. Lori says the judge is just taking the state's word for it. The judge is getting fed up, by the way. The judge said Lori wants him to just take her word for it that the state told him that. The judge mentions Nate Eaton also hired an attorney that said the same thing, which Nate Eaton, I listened to him. He said he had an attorney work with him on that document. So if Lori is complaining about the wording, it's coming from his attorney, as far as anyone would know, right? Judge said that stating the law isn't an ethical violation, so saying he would need to be subpoenaed would be fine. Lori says, the judge says that Lori can interview Nate Eaton, have his investigator call him, and denied the motion. Now, the state alleges 11 felony convictions in Idaho, but there's talk of basically you got to limit these to the amount that the jury sees for prejudicial reasons. So the judge wants to limit the jury's knowledge to 2. The state wants 3 felonies. Lori wants none in her filings, but Lori says she hasn't had time to, come up with arguments, it sounds like. So the judge just tables this till later, because none of this matters unless Lori testifies. But here's the thing. The judge mentions it. Some of her felony charges include the word deception in the title. So if Lori testifies, the state, I assume, can use at least one of those deception charges as one of the charges they tell the jury, which ruins I would assume it would ruin the jury if they believed her, which I don't think they will, but if they did, it would not be a good thing to find out that she's been convicted of that. Talk of seating and precluding witnesses, talk of how the media's present. Judge confirms Lori has to wear a stun belt. She tries to argue that it wouldn't be needed because security, so if there's guards at the entrances, that she wouldn't need the belt. But the judge basically, if they have guards at the entrances, that's their decision. His orders, she's wearing that stun belt. In my opinion, a good call for the judge. Especially because she's particularly asking about it. The jury's not going to see it. My thought process is you don't give her that belt. She's not asking for it. She's going to do something, right? She's going to cause some issue, especially after today, seeing how she's starting to act out a little bit in court. I think it's going to be a mess. Now, the next few days are going to be jury selection. There's going to be no cameras in jury selection. But also there might be no media, because there's worries about the amount of seating available. But we'll see. We'll see how that goes. So you aren't going to get the Sarah Boone thing where you can watch them, go through the voir dire questions. Now, with all that said, there is, I do plan to cover this case when it actually, starts. Similar videos to this, longer, of course, more detailed, similar to what I did with the Sarah Boone case. With that being said, I'm trying to think. Those videos might come out later in the night, depending on how many other things I have to do, because it's not a good time of year. I still haven't done my taxes. I got to fit that in. I've got some other stuff I got to do for the other channel. I got to fit that in. I'm going to have to try to fit a lot of stuff in. So those videos might come out later in the day. But also this trial is more to the west, so time zones. I don't know how it's going to shake out, but I am planning to cover it. I do have right now Sarah Boone documents. They are transcripts from 2 days. Now, there's nothing super amazing there, but I'm thinking about doing a video, a little video covering the transcript of basically Sarah's character witnesses. I think that would be interesting to read through at this time. But yeah, this came up. I actually forgot there was a motions hearing today. I had to go unexpectedly get new tires, so that was sucky. Tires are expensive. I'm just gonna complain about that for a moment. They're expensive. So I had to get 4 new tires and grab some food for dinner. I still haven't cooked yet. So what I'm probably gonna do is put this video on and then upload it and then probably premiere it and then cook after. So because of that, I don't think the Sarah Boone stuff I want to cover will be tonight. So I'll probably schedule that for tomorrow. So if you're interested in that, it's going to be, there's a file on motion stuff. I don't think there's much I really would want to cover in a video for that, but I think reading through Sarah Boone's character witness transcripts will be fun, especially for anyone who didn't catch those live, because they were They were a treat. I'll put it that way. They were a treat. So, see y'all in the next video. Hope you enjoyed this one. I keep feeling so much Sarah coming out of her, but it's just they share a lot of the same energy, I gotta say. At least to me. I don't know what you think.